22-00-7738-01-FC. People of the State of Michigan versus Maurice Lee.
All right, thank you. Counsel, you may proceed.
Judge, you want my appearance?
Yes.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Reginald Andrew, your P80354, appearing on behalf of the people.
Thank you.
And good morning, Your Honor, and to your staff, Sophia Nelson of Neighborhood Defender Service, on behalf of Mr. Lee, whose presence I waive for the purposes of this hearing, P77960. The defense has filed a motion for an evidentiary hearing to challenge the procedures by which Wayne County conducts its jury veneers, as there's been several recent panels where there's been only one or no Black men present. The reason that this motion was brought in advance of—
All right. So what support do you have of that last statement that you just made?
Personal presence in the courtroom.
So, you know, for evidentiary hearings and evidence, number one, you need a veneer, and number two, you need an affidavit, and number two, you need to address the fact of this circuit court's being upheld on its veneers. So I'll leave that and go back to the prosecutor for a moment. Go ahead. As far as addressing what he just said, were you present? Did you receive an affidavit? What's
Judge,
your knowledge on the appellate court? Go ahead.
Judge, I've been present throughout the entirety of this case, and I've received no such affidavit.
All right. All right, counsel, go ahead.
Yeah, so I'm pointing, the reason that I filed this motion in advance and not based on the veneer that was paneled in this case is because of the Michigan Supreme Court's decision in People versus Bryant 491 Mich 575, which requires the defendant to bring a challenge to multiple over a course of at least 6-month period. And so in order to do that, I need the data that I don't have access to. And so that's why I've subpoenaed the Wayne County Jury Services to produce data at an evidentiary hearing. Maybe at that point of receiving the data, this issue would be moot. But given the Michigan Supreme Court's precedent in this matter, the defense is hamstrung, right? They cannot make a challenge based on their specific veneer because that's not what the case law requires. But they have to make the data based on the veneers over time, but they don't have access, and that information is not publicly available. And so that is why I'm subpoenaing that information and request that this court hold an evidentiary hearing at which the Director of Jury Services would testify and provide that data, at which point, you know, this issue may be moot, it may not be, but I'm happy to provide an affidavit both to Mr. Andrew and to the court concerning what I believe is a systemic problem that, again, based on ad hoc single off instances, it's hard to know if it's an actual systemic problem. And that's why the data is necessary. I do not believe that there has been recent data available based on the rulings in Bryant. And that is why I'm bringing this motion and asking that the Chief of Jury Services be required to produce that information, because Mr. Lee is now in a kind of catch-22 position where he cannot bring a challenge based on his specific veneer because Bryant doesn't allow that, but he does not have access to the information that would allow him to know whether there is in fact a systemic problem.
So your position is that you have sent Jury Services a subpoena for information on what? On how? What kind of time frame? Because, go ahead.
Well, that subpoena, when I believe that tomorrow we were having an evidentiary hearing, that subpoena was sent out well over a month ago, requesting specific data.
What specific data is my question?
Yes, it requested I'm going to read you all juror qualification questionnaires for the years of 2022, 2023, and 2024. The names and addresses of all jurors selected in 2022, 2023.
Okay, you understand that would be like millions of data sets. I mean, your
Yes.
years. We're the busiest court in the state. That would be all right. Thank you.
Yes,
I
and
got that.
I've
Now let's let the prosecutor respond to that.
I just briefly, Your Honor, I've retained an expert from U of M, the sociologist that can run all those data sets for me. So I'm well aware about the amount of data that is going to be here. And that's specifically why I have a demographer that's going to run those census tracts and actually determine statistically if Black men are being undersampled. That's why I need such a large data set.
Thank you. It's the prosecutor's turn to speak. Thank you.
And Judge, as the court indicated earlier, this issue is not ripe for litigation at this time. And the other issue that people take is the timing of this motion. We were set for trial. Defense counsel requested an adjournment, which the court denied, and then this motion gets filed. And we believe it's a delay tactic to prevent the trial from moving forward.
What's the trial date?
It was, I think it was back in November. Now it's been pushed out to March. And this is a 3-year-old case, Judge. And I'm pretty sure that Counsel Nelson has tried many, many cases in the last 3 years, and never once has a motion such as this been filed before.
Okay, so we got that on this specific timing when it was shortly before trial. That does seem inappropriate, but beyond that, counsel for the people, could you respond to more specifically, as you agree with the court that the issue is not ripe, can you address his contention that he on his on Bradley on his intent to try to argue the his support for an evidentiary hearing? Can you respond to that?
Judge, we believe the people's position is that the threshold has not been met at this time. Surely the first prong, that African Americans are a distinct group in the community, surely that's correct. But it's the other prongs to prove a prima facie claim. The defendant has to show the representation of African Americans is not fair and reasonable in jury veneers over time. Defendant fails to present any data showing that African Americans are underrepresented in Wayne County jury veneers.
Okay, and his response was that he's going to try to subpoena information, and as I state, I mean, I had already indicated that this would be speculative. It's really fishing for something that you have at this point no evidence of. So I can't grant it, but he go ahead. Is there anything else, Mr. Nelson or Ms. Nelson, that you want to address?
Yes, Your Honor. So as an officer of the court, again, this has been a more recent issue. I've been working now trying cases for several years, and in the last, I would say 6 months to a year, my office has had several veneers where there's only been one or no Black men, which is why the challenge was brought. This trial,
I mean, can I address something with you?
Yes.
Can I chat with you? So, given that you're talking about isolated incidences that you've seen in your few years in practice, how many trials have you tried, counsel?
Well, so Your Honor, I've been a lawyer now for over 13 years. I've been in many different areas, but
That's
I've only
not
been
the question.
the neighborhood defender service now for 3 years. I've tried, I think, 4 or 5 cases.
Okay, so
but
4
my
or 5
office
cases.
represents a third of criminal defendants in Wayne County. So I'm basing this on a third, like my neighborhood defender services observations as an officer of this court, that as of the last 6 months to a year, there has been many veneers that have been.
Can I ask that? I'm asking you a couple of questions, and you're not responsive at all. So you've tried a few cases, and in addition to that, how many times have you filed a motion of this type before you even before a jury is selected on the veneer? How many times have you filed this motion?
This is the first time I've done that because I filed one briefly.
Thank you.
on my
Let
last
me just
homicide case.
let me first ask my questions, counsel, so we can get through this a little quicker. Then you can say whatever you want. And then, have you read the appellate decisions upholding this court's current process for composing veneers? And I'm sure you are aware of the general fact that the court can only comply with a process for composing veneers and send out requests. We cannot, we don't have complete control over the responses that we get, and the court can only comply with its requirement. It cannot change responses and all of that. And we have you reviewed the appellate decisions on these issues?
Yes, Your Honor, I have reviewed the appellate decisions. I do disagree that the court isn't under an obligation to force compliance with subpoenas for jury service, so that the veneers that are
I
produced.
didn't say, that's not what I said.
Okay.
What I said is that we don't have control over the actual specific outcome, but processes and complying with processes is required and is complied with, and you have read those appellate decisions. So what else is it that you want to say before the prosecutor gets to respond?
So I did file a motion challenging the veneers in my last homicide trial when the veneer was impaneled because of this issue. And the court correctly pointed to People versus Bryant that it's not appropriate to bring the challenge at the time the veneer has been paneled. In fact, it needs to be brought in advance, challenging the whole system. And so that is why I filed this motion in advance of a panel being, a jury being impaneled in this case, challenging the way, not.
What court was that?
It was Nicholas Hathaway, Third Circuit Court, and People in a homicide case that I had recently.
All right.
So that's why I have now done it. After reading Bryant, I agree with Judge Hathaway that the proper process here is to file it in advance of a jury being impaneled. And I don't know how we can know whether the people who actually show up for jury service are a fair cross-section of the community if we don't have that data available to the public or to defendants who are facing trial in Wayne County.
Prosecutor's response.
And Judge, surely the court sends out these notices, and it's up to the people of the county of Wayne to respond truthfully and make themselves available for jury trials. If they don't,
I'm not asking for that response to what he's saying about the prior court's ruling, about Bryant, the interpretation of Bryant, all of that.
I agree with the appellate court's original decision, Judge, and that there is no basis for this motion.
All right. You know, at this time, with no affidavit, with no supplements on either side, the court cannot grant the motion. This case had been set for trial in November. No jury has been selected. The issue is not ripe. The court's process for composing veneers has been addressed and upheld by appellate courts. And at this point, the defendant's motion is wholly speculative. There's been nothing that has been submitted to this court to support any facts that would support that defense counsel should have a trial that's set in last November and shortly before the trial, pause the trial and delay the trial. It could be a delay tactic to file this motion. And then he says 1 month ago, which is way after the November trial, sending the jury services a subpoena for information that would amount to millions of data sets. And on an issue, I don't, where the felony cases have a 90-day track, this would not seem to be supportable at this point in any way. And so this court would deny the motion for an evidentiary hearing at this point.
Would the court entertain a motion for reconsideration once an affidavit is filed concerning NDS's numerous experiences with juries that are not representative of the community?
You know, at this point, you had every opportunity to bring that, and you did not in this motion. So it's not new evidence that you could not have obtained. So no, thank you.
Okay, can I get a written order to that effect for appellate purposes? Thank you.
You have the prosecutor or the defense can submit an order. I'll sign it.
Thank you, Your Honor.